My name's Sam. I am the Managing Director of Sable International Australia. I'm also a migration agent, a registered migration agent here in Australia. I've been working in the industry for over 20 years. I have processed countless numbers of partner visas. I've forgotten how many I've processed. Um, and my colleague, and I'm in Melbourne, so I'm in our Melbourne office. And Jamie, you can do your intro. Where are you calling in from?
Yeah. Yeah. So I'm based in our Cape Town office. We have a team here, and I manage that team, a team of caseworkers and administrators that just sort of drive the process from the back end. Often the first point of contact for any clients, potential clients offshore, just obviously with the time zone. Sam's sleeping, so unfortunately he's not available 24/7, but that's where we step in.
Yeah, so we have a lot of coverage in our team. So obviously we're here in Australia and Jamie's team is in South Africa. So like Jamie says, you often talk to her first, and myself later in the process, and both of us throughout the process if you choose to engage our services. So we're going to do partner visas today. Um, and there's a lot to cover in partner visas. This is our agenda today. Different types of partner visas, eligible relationships and qualifying periods, understanding the two-stage partner process, relationship evidence, key tips and examples, health and character, where to apply from, bridging visas, processing times, common mistakes, and we'll do some Q&A at the end. There's a lot of content. We could speak for hours and hours and hours, but that's not
Yeah.
really what we want to do today. We want to give you a little bit of everything, but not too much content to overwhelm you. I hope we're helpful. We are here to assist you throughout the process should you want to engage our services. So feel free to get in touch. The webinar will be emailed to everyone sometime after the webinar is delivered. So all our contact details will be provided to you on that email. So let's get into it. So different types of partner visas. So the first one we're going to talk about is subclass 300, the prospective marriage visa. I mean, it's not quite a partner visa because you're not applying for a partner visa, you're applying for a prospective partner visa, a prospective marriage visa.
Yes.
So the 300 is for people who are not married, who have not lived in a relationship, in a de facto relationship for more than 12 months, who have not registered their relationship. But they must have met face to face, and they must have intentions to get married. So it's commonly called the fiance visa in the industry because it's for people who are engaged to be married, and who have intentions to get married in the future. It's a good visa for people who, for whatever reasons, cannot comply with the requirements of the partner visa of the 309 or the 820, but have intentions to get married sometime in the future. It's always my advice to clients that if you can avoid doing the 300 and you can skip straight to the 309 or the 820, then do that. You will save yourself time and money by avoiding the 300, but it's not possible for everyone. So the 300 is there for a purpose, and it serves a good purpose for those people who need it. You can only apply for the 300 from outside of Australia, and you need to be outside of Australia when it is granted. You can travel to Australia whilst it is in process, but you can't be here when it is granted. Once it is granted, you can come to Australia. You have full work rights when you arrive. The requirement is that you get married before the visa expires, and then before the visa expires and after you are married, you then apply for the onshore partner visa, which is 820. So yeah, key takeaways: you must have met in person. You can't have just met online and apply for the prospective marriage 300. You have to have met in person after the age of 18. Yeah, so fit for purpose, but
Yeah.
not my first
Quite.
choice if we can avoid it.
Yeah, I agree. It's quite the stepping stone process to get to the ultimate end goal, obviously, of having a partner visa. So, yeah, absolutely. I often see clients obviously doing their best to move on to straight to a partner visa where possible. But like Sam said, definitely occasions where that's not always possible. And a 300 is just the best fit.
For sure. So what we do more of is the actual partner visa, which is an offshore partner visa or an onshore partner visa. So the partner visa is relatively the same as far as criteria is concerned, but there is a clear distinction between those people who apply from outside of Australia and for those people who apply in Australia. So for those applying outside of Australia, it's referred to as a 309 and a 100. We'll get to what the 309 means and what the 100 means, but just for now, we'll talk about that as an offshore partner visa. These are for people who are married or in de facto partner relationships, or perhaps are in a civil union also. The 309 is the temporary, the 100 is the permanent. We'll expand on that later. You've got to be outside of Australia when you apply. You can be here in Australia at the time of grant. That wasn't always the way. The rules did change during COVID and post-COVID. The 820 is the onshore partner visa, again, for married or de facto partners applying from within Australia, or for people who have civil unions or registered relationships. And we'll get to that later as well. The 820 is the temporary, the 801 is the permanent. In order to apply in Australia, you must hold a substantive visa. It's not entirely true that there is Schedule 3 criteria that we could talk about, but it's quite technical and we could be here for hours talking about Schedule 3. But most people will need to be holding a substantive visa in order to apply in Australia and submit a valid application. If you don't hold a substantive, then you'll need to meet Schedule 3 criteria, and we haven't got time to discuss that in this webinar tonight. So we're not going to.
Give us a call if that's the case.
Yeah, that's right. It's a little bit more technical. Let's move on. So eligible relationships, types and qualifying periods. So all relationships must show a mutual commitment to each other, to the exclusion of all others, is what the law and policy says. It must be a genuine and continuing relationship. People must be living together or not living apart on a permanent basis. People must be not related by family. The question that I get somewhat is the living together or not living apart on a permanent basis, and it's a relatively common question, so I'll address it now. I'll give the example of a fly-in, fly-out worker, people who might, I'll use the example of an offshore oil and gas rig. So someone spends 3 weeks of the month working on an oil and gas rig offshore, and then spends 1 week onshore living in their primary place of residence. So that person actually spends more time away from their partner than they do with their partner. Are they living together or are they not living permanently apart? Their main place of residence is with their partner. Where they happen to work happens to be somewhere else, and work takes them away from their main place of residence. But for that scenario, they are living together and they are not living apart on a permanent basis. There's other examples that can be cited where people have lived together but then are forced for whatever reasons, and it could be restrictions of visa and immigration rules, that people are not living together at the time that they apply, but they can be considered not living apart on a permanent basis. It does come down to individual circumstances, and each individual circumstances must be addressed on their own. So, but it's a common question, and one that people often think prevents them from applying for a partner visa, but it doesn't necessarily, and needs to be discussed in detail. So additional requirements based on the relationship type. So you're either married or you're in a civil union or a registered relationship, or you're a de facto couple. Now, if you're a de facto couple and you're not married and you haven't registered your relationship, then you must have lived together for a minimum period of 12 months in order to meet the regulations. If you're married, then you can apply the next day. You can meet your partner today, get married, next week, Las Vegas, the drive-through chapel, whatever it may be, and then apply for a partner visa. There's no time restriction based on people who are married. You can apply for a partner very soon after being married, despite how long you may have known each other. De facto couples must have lived together for a period of 12 months. People who have entered into a civil union or registered their relationship are treated the same as married couples as far as the law is concerned, and therefore, once you've registered your relationship, you are then able to also go and apply for a partner visa. You don't have to have lived together for a period of 12 months. So really, it's the de facto couples who have this restriction of time placed upon them, and that is for a period of 12 months. The registered relationship laws here in Australia are state-based laws, and not all states here in Australia have registration of relationship laws. For example, Western Australia does not. So you're not able to register your relationship in Western Australia. So some people who live in Western Australia who don't want to get married or can't get married for whatever reason, also can't register their relationship, and therefore might have to live together in a de facto relationship for a whole 12 months before they're eligible to apply for a partner visa. Jamie, did that make sense? I feel like I just
No,
rambled off
it
there.
does. I mean, well, it makes sense to me. But no, I think that
Thank
that's a simple way of explaining it. I know that the slide obviously does allude to compelling or compassionate circumstances. Sam, I don't know if you want to touch on that. I'm not sure if anybody in the audience might have that kind of a situation.
Yeah, sure. Okay, so the policy does say that if you're in a de facto relationship, you're not married to your partner, and you've lived with that person for less than 12 months, it is possible for you still to apply based on a de facto relationship if there are compelling and compassionate circumstances, one of which cited in policy is that you have a child together.
Yeah. I had a case
So,
like that quite recently where they were asking that exact same question. So yeah, absolutely it is possible.
it is possible if you have compelling and compassionate circumstances, which is
Yeah,
a difficult threshold to
it is.
satisfy, but there's an example.
Yeah.
All right, moving on. Understanding two-stage partner processing. Okay, this is a concept which often takes some explaining. So when you apply for a partner visa, you're making what is referred to as a combined application. The partner visa is fairly unique in the Australian immigration system insofar as you're applying for two different subclasses at the same time. The subclass is the numerical value that we give to the visa. So when you apply for the onshore partner visa, you're applying for the 820, which is the temporary, and you're applying for the 801, which is the permanent at the same time. You're making a combined application. Same goes for offshore. You're applying for the 309, the temporary, and the 100, the permanent, at the same time. The policy that the department have is that when they assess your application, they will assess you under both sets of criteria, and the permanent and the temporary have different sets of criteria. So the caseworker at the Department of Home Affairs sits down and looks at your case and initially assesses you under the temporary criteria and goes tick, 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 yes, meets the criteria of the temporary visa. I'm going to grant that visa now. They're granted. And then looks at the permanent criteria and says, does this person satisfy the permanent criteria? Goes through the list. If yes, then they will then grant the permanent visa at the same time. So for those people who satisfy the permanent criteria, they get two visas granted on the same day. They get the temporary visa and they get the permanent visa granted on the same day. They get a double grant. Now, for everyone else who doesn't satisfy the permanent criteria, they'll get their temporary visa, hopefully, if they satisfy temporary criteria. But the permanent visa will be set aside. And the permanent visa is set aside for 2 years from the date of application.
Yeah,
Now,
I think that's important to stress. Yeah, from the date of application, not from the date it was granted.
Yeah, that's right. So if the application is being assessed 12 months after it was submitted, then you've got another 12 months until the permanent partner criteria can be or is eligible to be assessed again. So let's deal with the direct permanent grant. So, and everyone wants this, and everyone asks Sam, Jamie, am I eligible to be granted a permanent visa straight up, or will I have to go through the two-stage processing? You're eligible to be granted a permanent partner visa if you've been in a genuine de facto or married relationship for 3 or more years, or you've been in a genuine married or de facto relationship for 2 or more years, and you have a child at the time of application. So those are basically the two sets of criteria that you need to satisfy in order to be granted a permanent visa. For some of our clients, we will delay submitting an application by a month, 6 weeks, 2 months, maybe more, if it means that at the time we submit, the client has the 3 years required or the 2 years plus child requirement in order to be granted the permanent visa. It's in their best interests and ours that they are granted a permanent visa from the outset where possible. For some clients, we might need to put in a really strong submission to stress to the Department of Home Affairs and to the decision maker that this person should be granted a permanent visa because they do satisfy the criteria. And we might need to stress that because some of their documents might be a little bit weak, and we might need to point out to a caseworker just why exactly they should make this consideration and they should make that grant. Is that right, Jamie?
Yeah, absolutely. We have to make it quite plain, quite clear, really lay it out for them on a silver platter and show them exactly how you've met the direct to permanent. We've had situations where, let's say, for instance, I don't know if the delegate's feeling a little lazy that day and just grants the temporary and misses the fact that this was direct to permanent, and you've often got to go back and sort of be like, excuse me, can you please process this direct?
It's true. There's examples, and more than one, maybe, one a year, maybe not that many, but there's examples where people who definitely satisfy the grant of the permanent visa are only granted a temporary visa, and we have to go back to the department and say, hey guys, you need to have another look at this. You should have granted the permanent visa. Ordinarily, yes, they do. Temporary first, permanent later. So if you are less than the criteria set out above, which is 3 years or 2 years plus a child, then you're going to get the temporary visa, the 309 or the 820. It's not a big train smash. It's not something to be saddened by. You've got a visa, a substantive visa, which allows you to travel into and out of Australia at your will. There's no requirements that you must live in Australia for any period of time in the initial 2 years. That's the common question that I get, saying, I've got this temporary visa. In order to be eligible for the permanent visa, do I have to live in Australia for a period of time whilst I'm on the temporary visa? The answer is no, you don't. There's no residency requirements in order for you to be granted the permanent. The requirement is, as we've said already, 2 years from the original date of application. You will be eligible to submit further evidence to the department to demonstrate that the relationship is genuine and ongoing. So at the second stage, the application for the second stage processing for those who are going from temp to perm is very similar to the first application. It's online, there's an application form, there's documents required, you go back into the queue, etc. The big difference is that there's no application fee. You don't pay a fee to the Department of Home Affairs because you paid the fee up front when you made the combined application.
Yeah,
have I missed anything there,
definitely.
Jamie?
Yeah, absolutely. I'm glad you stressed that point, because a lot of people researching the partner visa seem to think that there's the second fee, and I mean, it's already such an expensive fee up front. So obviously, quite the relief. No, there's not a second fee, and yeah, like you said, free to travel, free to work, pretty much go about life as normal on the temporary. It's definitely not a bad outcome. It's a great visa.
So I guess we should talk about the differences. As a temporary resident of Australia, you don't normally have access to Medicare. If you've submitted an application for a permanent visa in Australia, however, you do have access to Medicare. As a temporary resident, you might be restricted from applying for some jobs. Some government jobs don't allow you to work within government if you're a temporary resident. You certainly can't vote in Australia as a temporary resident or as a permanent resident. But you won't see much of a difference, to be honest, between the temporary and the permanent visa.
No, perfect.
All right, moving on. Relationship evidence requirements, key tips and examples. So the subclass 300, the prospective marriage visa, like I said earlier, you must have met in person. You must show intention to marry. Types of evidence, you will include photos. You'll include travel records to show that you've met each other in their home country or your home country or somewhere around the world. You'll talk about your engagement plans. Here in Australia, we have a form that we have to fill out in order to get married here in Australia. It's called the Notice of Intent to Marriage form. You will submit that form with your application. You'll show evidence of your wedding arrangements, if you've bought an engagement ring, if you've booked a venue, all those types of things you can include in your application for prospective marriage. You don't have to show that you have joint financial responsibilities at this point in time. You're welcome to show extra additional evidence like joint financial responsibilities if you happen to have them, but you don't necessarily have to. Whereas for the 309 and the 100 and the 820 and the 801, you must demonstrate what we refer to as the 4 pillars of the relationship. And that's not the name that we give to these 4 components. It's the name that the department give to these 4 components. They refer to them as the 4 pillars of the relationship. And they are the financial aspects of the relationship, nature of the household, social aspects, and nature of the couple's commitment to one another. Now, financial aspects is probably where most weight is placed. So we stress to our clients, where possible, try and open a joint bank account. Try and have, a joint bank account that you use for joint liabilities, that you pay your outgoings from. You have your own personal bank account, your partner has their own personal bank account, but then you also have a joint account, and you both put in a nominal amount of money into the joint account on a weekly or monthly basis, and you use that joint account to pay your rent, to pay your mortgage, to pay your utilities, to pay your groceries, to go out for dinner and the movies, whatever the case might be. All those joint liabilities come out of the joint account. That's just the way the Department of Home Affairs want to see it. My parents have been married for 55 years. They don't have a joint bank account, okay? And a lot of couples say, well, we've been together for like 10 years. We've got 2 children. We don't have a joint bank account. Do we need a joint bank account? No, you don't need to. You don't have to have a joint bank account. For some couples, it's a good addition to a portfolio of evidence if they don't have a lot of evidence. And for some couples, it's totally not necessarily. But for the Department of Home Affairs, they do place a lot of weight on joint financials. You can do joint financials in different ways. You can do joint liabilities, for things that you are paying for, like your tenancy, for example. There's different ways to present joint financials. Nature of the
Some clients have
household.
additional card holders. Sorry,
Yep.
sometimes there's additional card holders to accounts. Some countries don't do. I mean, obviously in South Africa, I'm from South Africa, we can't do joint accounts, but we can have additional card holders to our accounts. So your partner still got access. The funds are still very much shared, and it still demonstrates that sort of commitment to the department if they want to see that level of commitment and pooling of financial resources.
Yeah, for sure. Good point, Jamie. Some countries don't allow you to have joint finances or joint bank accounts. So it's not the be all and end all, but it's something that we do advise where possible. The nature of the household, the social aspects of the relationship, and the nature of the couple's commitment to one another are 3 aspects which are very individualistic to your particular set of circumstances. And you will be given an opportunity to talk about these in length in what we refer to as the personal history statement, which is basically a story about you, your relationship, when you met, when you first moved in together, your plans for the future, how you run your household, what you do socially, what your commitments are, etc. We've given you examples here of documents that you can provide, but everyone is very individualistic on these particular components. Is that right, Jamie?
Yeah, no, I've not seen 2 relationships that are the same or run everything the same or divide everything the same, or every situation is very, very unique.
Yep. So we suggest that you provide a variety of set of documents across the 4 pillars across the course of your relationship. Look, if you've been in a relationship for 20 years, and there's no reason for you to provide evidence across the whole of the 20 years. The department will concentrate on the past 3 years. But if you do have documents that you can reference from, a long time ago, then certainly you're welcome to put them in. Something that we advocate for with our clients is we don't want you to do unnecessary work, to provide unnecessary documents. We don't want you to provide a bank statement for every month for the past 3 years. It's unnecessary. So there's a level of documentation that you need to provide which is meeting the criteria, and then there's an excess where you're wasting your time, you're wasting the department's time. It's about finding that happy medium. Is that right, Jamie?
Yeah, absolutely. I think that's another common question that we get from a lot of clients. Just how much do I have to give? Do I have to give all my bank statements from the last 10 years? Definitely not.
No.
Yeah, the length of time you've been in your relationship and what goals are you trying to achieve with this application? If you're eligible for being processed direct to permanent, of course, we want to cover that period, but to what level? It obviously depends on the evidence and length of the relationship.
Yeah. All right, moving on, the health requirement. Okay, so all applicants who are applying for a permanent visa for Australia, regardless of the subclass, must demonstrate that they meet the health requirements. Typically, you will be sent for a medical examination. The medical examination includes a chest x-ray. They're looking for tuberculosis, and they will also do a general physical, medical. They will take blood tests, etc. The purpose of the health requirements is to ensure that applicants do not present public health safety risk to Australian citizens, or that they may be using an amount of public resources here in Australia. The big one, really, the big question when you do health is, do you have a health condition that is going to incur significant costs when you get to Australia? And they apply what is referred to as the hypothetical persons test, which basically says that if you were an Australian citizen or permanent resident and you had access to our health system, what would you, the hypothetical person, be able to access as far as health services are concerned, and what would those health services cost the Australian taxpayer? Now, if it's over a certain amount, then that will potentially mean that you fail the medical requirement. Yeah. So
Yeah.
in the partner visa, and the partner visa is fairly unique in this particular point, but in the partner visa, there is what we call a health waiver. So if you do happen to fail the health requirement because you have a condition which is likely to incur a high amount of costs, then you have an opportunity to present a health waiver. And the health waiver basically gives you an opportunity to argue your case, to say for a lot of different reasons why they should still grant your visa. And there can be compassionate reasons, there can be financial reasons, there can be community reasons. There's a lot of different reasons that you can draw upon in order to submit a health waiver to convince the government why you should be granted the visa. Jamie, we've done a lot of health waivers. For a lot of clients. Some examples of health waivers of people who have conditions who have failed the health criteria.
We've had a client with HIV who failed the initial, obviously, the health requirement. We did a health waiver, and obviously that got across the line. He got his visa granted direct to permanent, so he's a permanent resident today. We've had everything from, gastric issues to mental health issues. And it's been quite varied. I will say that the health waiver it's quite an administrative process, and there's certain timelines that apply when you're doing it. The department obviously will allow you the opportunity to apply for the health waiver, give a period of time to submit it, and so it's definitely it's a lot of evidence to pull together should it happen. And I think that's probably where I really would stress, if you're going through this process, that's probably where you're definitely going to need a migration agent to assist. I wouldn't necessarily attempt that on my own personally.
Sure.
But yeah, it's definitely a bit more complex.
The other thing about the health requirements is, again, it's very individualistic. So your particular set of circumstances need to be addressed, on your particular matter, and you can't use a one size fits all. So, and there's no way of telling you up front if you're going to fail definitively no one can tell you up front if you're going to fail the health waiver or not. It's a matter of going through the process, unfortunately. Very few people fail the health waiver. it's something
Yeah.
which happens occasionally. Yep.
Absolutely.
Character test. So everyone needs to do health and everyone needs to do character. The character test basically says that you need to provide police checks. Police checks must be provided for every country that you've lived in over the course of the last 10 years where you've spent more than 365 days living in that country. The character test basically says if you have a substantial criminal record, you've been sentenced to a period of imprisonment of 12 months or more, or you've been sentenced to death or life imprisonment. Look, we're probably not going to have that client on our books, but
Yeah.
if you've been sentenced to a term of imprisonment of 12 months or more, or a term of imprisonment or more than one term of sentences, which adds up cumulatively to more than 12 months, then chances are you're going to fail the character test. And look, we've had a number of different clients that we have represented who have had substantial criminal records, and some fail the character test and others don't. Again, it comes down to a particular individualistic point of view, and it needs deep consultation in order to determine whether or not you have an option for a partner visa. More so from a logistical point of view, police checks and health checks are valid for 12 months. Don't do them too early. They'll expire before decisions are made and you'll have to do them again. So just be mindful and careful of when you go and do these things, because you might be making more work for yourself by doing them too early.
Absolutely.
All right, key considerations when deciding where to apply from. So do we do an offshore or do we do an onshore? There's pros and cons. There's benefits to some. Some people have the option and some people don't have the option. So first of all, onshore, offshore, can you lodge your partner visa in Australia or from your home country? I mean, in order to lodge from Australia, you need to be here in Australia on a visa, which allows you to submit another visa application. So, you know, unfortunately, it does often come down to your citizenship and the level of risk that your citizenship provides to the Department of Home Affairs. So if you're a UK citizen, you're quite welcome to get a visitor visa subclass 651. You apply for it online, you don't pay a fee. It's normally granted quickly, even auto granted. If you don't have any criminal convictions, then it can go through very quickly. And then you can come to Australia and submit an application onshore. If you're from other more high risk countries, and I won't name any, but you probably know who you are. If you are high risk, then chances of you getting a visitor visa to come to Australia to apply for a partner visa onshore are probably quite low, and in which case you probably have to apply offshore. There's probably more benefits to applying onshore than there are to applying offshore, let's be honest. And so for a lot of people, we will probably advocate for them to come to Australia and apply here. And let's talk about why that is. So work rights. So the benefit of applying here in Australia is that you get a bridging visa, and that bridging visa has work rights. So if you want to come to Australia and apply here, then you may enter on a visitor visa, you may come on a working holiday visa, you might come on a student visa, you might be here in Australia on any number of different types of visas. And if it's a substantive visa that allows you to apply for a partner visa, then after you apply, you'll be granted a bridging visa. That is a bridging visa A, and when that comes into effect, you will have full work rights. For some people, though, you've got to think about, well, can I be unemployed in Australia for 3 months? It's not a cheap country to live in for 3 months if you're unemployed. So you need to think about that seriously. Are my circumstances such that I am able to sit around in Australia for 3 months without working? Look, you can go to job interviews, you can talk to prospective employers, you can be offered a job, you can sign an employment contract. You just can't start work until that bridging visa A kicks in. So that's a consideration that people need to factor into their decision making. Application strength. So some factors make your case stronger. So if you're living with your partner here in Australia, then that may strengthen your case. If you are living apart and you're at home in your home country, your partner's here in Australia, then that might not assist your application. So we might advocate for you to come to Australia to apply from here. If it's not possible for you to come to Australia and apply for here for whatever reason, and you're restricted, then that may be a negative in your application depending on your particular circumstances. So again, there's pros and cons of coming to Australia and applying here. Processing times. So processing times vary depending on where you apply from. Different countries around the world have different processing times. Some of the fastest processing times we see for our clients are for clients from the United Kingdom. Jamie, what's an example of processing times from the UK recently?
Yeah, generally speaking, you're looking at about it's difficult to say. 3 to 6 months used to be quite the norm, but we are seeing it stretch a little bit outside of that, possibly closer to 9 months at the moment. I would say anywhere from 3 to 9 months is probably a good buffer.
Yep.
Whereas other countries around the world, over a year, up to 2 years, it varies so much.
It does. Recently had a client approved a partner visa, and the applicant had been in their home country for 2 years from the time of submission, waiting. And you can understand the stress that puts on people, on relationships, where you can't be with your partner and you're waiting 2 years to be granted a partner visa. It's a long time to wait. So for that reason, people should think seriously about where they're going to apply from. Yeah, each situation is unique. Talk to a professional, talk to a migration agent, talk to a migration lawyer, talk about your set of circumstances. It might be that you have commitments in your home country. There might be lots of different reasons why you can't come to Australia at a certain point in time. Get some advice is a good tip.
Yeah, absolutely. And there's many occasions where obviously an offshore application is the best fit. So yeah.
Absolutely. Bridging visas explained. Okay, so bridging visas are complex and confusing, and we're only going to touch on bridging visa A's and B's here. There's C's and D's and E's, and the list goes on, but we're only talking about A's and B's here. So the purpose of a bridging visa, like the name suggests, is to bridge the gap between when the visa expires that you currently hold and when the visa is granted that you have applied for. It's designed to bridge that gap. So it allows you to stay lawfully here in Australia whilst your partner visa is being processed. The bridging visa A is granted to you automatically by way of an operation of law when you submit the partner visa. That means that no one decides on whether or not you're eligible for a partner visa. The system has already decided, no one decides on whether or not you're eligible for a bridging visa. The system has already decided, the law and the regulations have already decided based on your set of circumstances. If you're onshore holding a substantive visa, then you're eligible to be granted a BVA, and you will be granted a BVA. Happens automatically. It's in your inbox about 3 minutes after you submit, okay? Usually, not always. Sometimes technical issues mean that it doesn't arrive when it should.
Yes.
And then we have to go and manually apply or chase the department and make noise in order to get one. But the point is that you are automatically eligible for a BVA. It doesn't cost anything. There's no extra fee for a BVA. It just turns up you are eligible for the BVA based on your set of circumstances. The bridging visa is a temporary visa. And you will remain on the bridging visa until such time as a decision has been made on your substantive visa. The really big benefit on the bridging visa A, which is associated to the partner visa, is that you have unrestricted work here in Australia. There are nil conditions on that BVA. Don't let that BVA be confused with other BVAs associated to other applications, because the BVA for other applications don't necessarily have work rights. But the one associated to the partner visa does. You can't travel on a BVA. You need to obtain a BVB in order to travel. The BVB takes a couple of weeks to process or a couple of days, depending on. Costs $190, can be granted for a period of up to 12 months. We suggest that you apply roughly 4 weeks before your intended travel date.
I think one thing it's worth stressing, Sam, is just really making it clear that the bridging visa A doesn't come into effect until the visa that you're currently on expires. A lot of people think, okay, well, if I arrive in Australia today and I submit my partner visa tomorrow, I can get my bridging visa and start working. And unfortunately, that's not the case.
Yes.
You have to
Good
wait
point.
until the period of your visa has expired. So in the case of a visitor visa where you can stay for up to 3 months, you would be on your visitor visa for the 3 months, regardless of when in that 3-month window you applied for your partner visa before the bridging
Yep.
visa will come into effect.
So the only way for a bridging visa to come into effect, the triggering action to allow a bridging visa to come into effect, is the expiration of the current visa that you hold. That's why the bridging visa has been granted to you in the first place, in order to bridge that gap. So I've had clients who are on other visas, an employer-sponsored visa, someone's on a 482 visa, and they've applied for a partner visa, and they've got a bridging visa granted to them, but that bridging visa is dormant. It doesn't come into effect for another 2 years until their work visa expires. They didn't know this when they submitted their partner visa, and now they're really annoyed that they're stuck on their work visa and they want to be on their bridging visa. And unfortunately, there's no way of bringing that bridging visa into effect. They say, oh, what if I have my work visa cancelled? Will that bring it into effect? No, it won't. It's not advisable. So just be really careful of your understanding of the bridging visa system before you set sail on that one. This last point is a little bit technical, and we don't advise it if you don't know exactly what you're doing, but it is possible to enliven a bridging visa A for a person who has submitted an application for a 309. So if you lodge an offshore partner visa whilst you hold a substantive visa, and then you enter Australia on a substantive visa, you can then apply for a BVA to be granted to you. It will not have work rights though. And that's a key difference to understand. It is possible to get work rights if you could demonstrate that financial hardship is something that you may suffer without work rights. We do it relatively commonly. So it can be done, but it needs to be done in consultation with a migration agent or a migration lawyer, because it is rather technical. So I wouldn't suggest someone tackles that on their own. But it's a really great piece of policy to be able to use to your advantage if your circumstances are such that that would be helpful to you. I'm conscious of time. We've been doing this for 44 minutes already, and we're not quite at the end. So forgive me if I start racing through the end here. Estimated global processing time. So the Department of Home Affairs publish all their processing times. You can visit the Department of Home Affairs website and see them in real time. They're updated daily. So subclass 300 prospective marriage visas, 90% of applications are processed within 25 months. Oof, it's a long time. Remember, that's a global average, so that takes into consideration all persons applying from all parts of the world, all different risk factors. Most of our clients are probably processed in somewhere around 12 to 14 months. Jamie, is that right?
Yeah, for 300, yeah.
Yep, 309s and 100s, 50% processed within 14 months and 90% processed within 24 months. 820s and 801s, 50% processed within 15 months, 90% processed within 19 months. The difference in processing times reflect your location when you submitted and where your application is allocated or triaged to for a particular processing team. Some processing teams have more staff, therefore they process more and more quickly, or they have less applications to deal with. So processing times vary depending on your location when you submit. Keynotes, processing times vary on location. I've spoken about that. They vary on individual circumstances. Applications can be prioritized for compassionate or compelling circumstances. It's difficult but possible, and each case is dealt with on a case-by-case basis. Generally speaking, applications should be dealt with in the manner in which they are received. So oldest applications which were lodged first will be processed first, generally speaking. Anything else to add there on processing times, Jamie?
No, I think it's pretty bang on. Unfortunately, it's the biggest question. How long is it going to take? Even for clients with applications in the queue, it is impossible to predict. There's just so many factors that impact it, and you can't compare to a friend of yours that might have submitted and is waiting and got it in X amount of time for these exact reasons. There's just so many varying factors.
Yep. So, common mistakes to avoid: weak relationship evidence. Failing to demonstrate a genuine ongoing relationship that meets the criteria across the 4 factors can lead to refusal. Tips: provide clear examples of 4 relationship factors: financial, household, social. So I had a call the other day from a person who'd submitted their own visa application, and unfortunately, whilst the relationship has been genuine for anywhere up to 2.5 years, they only have evidence for the past 10 months from the time of application. They literally don't have any other evidence. They shouldn't have submitted when they did. They didn't have enough evidence when they submitted. They thought, based on what they told the department, would be sufficient. The end of the day, if you don't have a document to back up what you're saying, then no one's going to believe you. You can say that you've been in a relationship for 3 years or more, but unless you've got a document that places you together at a particular address, living together, cohabitating, then the department's not going to believe you. So you've got to be able to back everything up through documents. Inconsistent information, conflicting statements, critical dates which don't match up. These are all red flags to the department. So ensure that your application has accurate dates which match up to one another. Not seeking professional guidance, misunderstanding visa regulations, applying for the wrong type of visa. I mean, I've been doing this for more than 20 years, and I've heard a lot of reasons as to why, if someone had just had a talk to a professional, they could have saved themselves a lot of grief. So just have a consultation with the registered migration agent and consider engaging their services. The application cost to the partner visa is 9,365 Australian dollars for the primary applicant. It's non-refundable if it's refused. So be cautious in how you tread. Make sure that you know what you're doing, and that you're confident in your understanding of the visa before you submit it. Because if you're refused, you're not going to get your money back. You might be able to submit an appeal, but the appeals take 2 to 3 years, and it will mean a great amount of heartache to you and your partner if you're wrapped up in the administrative reviews tribunal for 3 or 4 years. Again, great tip: engage a MARA agent to manage your application, or to consult with at the start, to ensure that you mitigate risks and delays. All right.
It's the insurance
like
for your
race
case,
here.
if I can put it that way.
Well, yeah,
Don't you
it
think,
is,
Sam?
isn't
A
it?
little bit like
Yeah,
insurance.
yeah, it is. And look, to
I
that
don't
point,
service my car. I don't do my taxes.
yeah, that's exactly right. I used to do my taxes, and I got a tax bill for a lot of money. I'm like, well, I think I did something wrong, and now I don't do my taxes anymore. We provide a service whereby if we take you on as a client, we'll guarantee success. We'll guarantee that you will be approved your partner visa. If you're not, then we'll refund to you any fees that you've paid to us. Why can we do that? Why can we provide you that guarantee? Because we've been doing it for more than 20 years. And I can look at you as an applicant, and I can tell you, based on the information that you've provided to me, that if you can back up everything you're saying, then there's no reason why you shouldn't be approved the visa, and I'll guarantee that you will be approved. I don't take on all clients because I can't guarantee all clients. Some clients come to me with certain situations, and I'm like, sorry, but based on your particular set of circumstances, I can't guarantee you success. But for those people who want a level of comfort and want to mitigate risks, then consider engaging a migration agent, whether it's us or someone else. All right, that is 50 minutes of me talking, which is way too much. So if anyone's got any Q&A, if anyone's got a question, then you're welcome to pose it to me now. If not, then you're welcome to get in touch with the team in Cape Town, or with our team here in Melbourne, and we'd be happy to answer any questions you have over the phone or via email.
definitely worth mentioning our initial consultations are at no charge. We don't charge for initial advice. Happy to assess, happy to give some general advice, help qualify you and advise, which route to take. Only then, obviously, would a fee apply and we take you on as a client if that was the route you wanted to go. But yes, please give us a call. It's free. Why not ask?
Give us a call. Get in touch. We're friendly people.
Yeah, actually, no questions coming through, so that's fine. If anybody's shy, like Sam said, give a call. I'll be in office all day today, so feel free to give me a call after this. The webinar will be emailed to you shortly once we've wrapped up here. So please check your inbox, check your spam in case it goes to spam. And yeah, look forward to hearing and helping you guys.
Thanks for attending, everyone. Hope you found it helpful and informative, and we hope to hear from you soon.